Mr. Gertie.
My lords, my lady, good morning.
Good morning.
Yesterday I was adverting to the fact that the appellants tried to limit our reliance on the factual findings by saying that you had to look, or essentially by saying that you had to look at the sections of the judgment in isolation and that you can't read findings in one section into the other. And obviously they're especially keen to exclude things like paragraphs 749 to 751. Now, in my submission, that's obviously misconceived in principle. One has to look holistically at the judgment in a fair way. But in any case, it's misconceived on the face of the judgment. If I could ask the court, please, to turn up the judgment, that's core bundle tab 5. Page 358.
Can I ask you to stick to paragraph numbers, because
Yes.
in order to get a double-sided version, I printed it off and did a form that doesn't have page numbers.
It's a 1237.
1237.
And the judge there expressly adverts to the fact that there is a substantial overlap with the alleged fraudulent independence claim that I pointed out yesterday. And as he said, in the claimant's written closing submissions, the two cases were basically addressed together. And then he goes on at 1238 to say that his conclusions in section H effectively dispose of the case on fiduciary duty and dishonest assistance. Obviously, when one goes to section H, as we will in a moment, that in turn refers back to, in particular, sections E and F, but also bits of section D that are relevant to that inquiry. So the judge is making clear on the face of the judgment in my submission that he's incorporating all of those relevant factual findings into section I, which on its face is obviously quite a short section, but that would be, it's deceptively short because it obviously incorporates everything that's gone before. So, returning to the two pillars that I talked about yesterday, looking first at the first pillar, that's the appellant's knowledge of Mr. Megani owning the general partner and therefore controlling what happened with the fees. Could we please pick that up at paragraph 1173, that's on page 343.
I'm so sorry, could you just give me that again?
It's 1173.
Okay.
And the judge there makes clear the interrelation between what I've called the two pillars. So it was disclosed that he was the entrepreneur behind the fund and had set it up. That's my pillar 2. I probably should have done it the other way around, shouldn't I now? And, the important word, and that he was the owner of the general partner. And as I said to you yesterday, and as we'll see in a moment when we work through, being the person behind the fund and setting it up is the judge's shorthand. He uses that phrase a lot, behind the fund. But the important point is that the court needs to understand what he meant by that, and in order to find out what he meant by that, one has to look at the earlier parts of judgment. If we could please move on to paragraph 1194, that's on page 348. The first sentence there makes it absolutely clear that the judge understood the essential case that the claimants advanced below and which they've effectively resurrected on this appeal. And if we pick it up at about a third of the way through, however, in my view, the important point which I'm here considering is whether they were told of his involvement. and I'll just let you read that for yourselves, if I may. This is one of the occasions on which the judge himself expressly refers back to section F. But in my submission, even if he doesn't in every paragraph refer back to section E or F, he is obviously, on a fair reading, incorporating those earlier findings.
Just pausing there briefly, the judge says once a person knows that Mr. Megani owns the general partner, it becomes obvious, and so on. I mean, that depends on the sort of person, doesn't it?
Of course.
I mean, plainly, if the average man in the street were told that Mr. Megani was the general partner, they wouldn't make anything of it. So the judge has in mind here the recipient of the information.
Absolutely, and I accept that. But that's just a function, as we'll see in the authorities in a moment, of this being a completely case-specific question. You have to look at your actual principles. And, my lord, immediately after that, the judge says that is reinforced if the person knows that Mr. Megani is the entrepreneur behind the fund. So this is my point about the twin pillars. The judge is saying, of course they know he's the general partner, and it's obvious to somebody, to people this sophisticated, what that means, and it's reinforced. So that's, you can't ignore all the stuff in section E, in section F, about the initiator, etc. And also, as the judge points out here and elsewhere, an entrepreneur would be understood to be the person who set the business up in the hope of making money from it. Again, to take my lord's point, that obviously means these people. And then we move on, please, to paragraph 1195, and we pick it up about a third of the way through. Investors in the fund knew, : it was irrelevant what the general partner did with its surplus assets. He could have paid a dividend for the whole of its twinkle perfectly legitimately, or it could have given it to a charity. And the obvious point there is that these claimants would have understood that, because when one looks at the offering memorandum, which the judge found they read carefully, it's obvious that the general partner has complete control over the funds that are paid, the fees that are paid to it. Its only obligation, once it's got the fees, is to pay off the service providers, such as VP. But as I said slightly facetiously to the judge below, in theory, what it didn't pay to VP, the general partner could have just given to the cat's home. And it's hard to see how the appellants could have any complaint about that, because they knew that the general partner had complete dominion over that money once it was paid to it. Then if we could please turn forward to paragraph 1196, the final two sentences at the top of page 349. That tends to suggest that investors considered in substance that they were looking to Mr. Megani as the entrepreneur who'd started this line of business to make it work. That is entirely consistent with the evidence discussed in section F. So again, the judge doesn't have to keep saying this, but he does expressly incorporate. The usual and significant involvement of an initiator in a fund of this kind, and obviously the appellants knew that. And then if we could move forward, please, to paragraph 1201, page 350. To pick up my Lord Justice Newey's point, this is where the judge explains that what he really means is MDM and Mr. Nutso appreciated all this. Paragraph 1203, the judge says, they, that's Mr. Nutso and MDM, knew who was behind the fund and its general partner. The and there again is this interrelation between being behind the fund and owning the general partner. Of course, they're just really two sides of the same coin. They're not strictly divided. But the judge, at least for the purposes of exposition, uses that those twin pillars. And the obvious point is that the reason they never had a single bit of communication with BP was because they were looking to Mr. Megani, the man who had impressed them. And the judge elaborates a bit on that in para 1204. Essentially saying, plainly, such extremely sophisticated investors would not hand over 102 million euros to a fund that had no track record, because it had literally just been set up, to be managed by a Liechtenstein-based banking institution they'd never heard of, and with whom they had had no contact, and into whom they did no due diligence at all. The obvious answer, says the judge, is that they knew exactly who was managing their money. It was the people that they had by this point been working with for some time. And again, over the page, I think that it's far more plausible, etc., etc. And again, the judge makes clear there that the two pillars, ownership of the general partner and the fact that he was the entrepreneur behind the fund. To my mind, says the judge, that's why Mr. Nutso used the expression the XY funds. Because as we saw, this is one of the paragraphs my friend took you to yesterday that he was trying to exclude from consideration. The judge found that the appellants saw the fund as being synonymous with XY. And then 1205, again, 2/3 of the way through, I am dealing in the present case. And this again goes back to the point that obviously when the judge talks about investors and persons, he means these people, and in fact he is finding that these people understood that. Similar point made in 1206. Then at 1207, the judge deals with the point that my learned friend raised yesterday about how the offering memorandum didn't identify who owned the general partner. Now, I won't bore you too much with this, but below, the appellants had a case that there were various legal obligations under Luxembourg law to disclose various things in the offering memorandum. And you may have picked up in your reading of the judgment that basically by the time of closing they'd abandoned that case. So they had made but abandoned the case that the offering memorandum breached the law which governed it in what it did and didn't identify. In any event, the judge deals with the point in substance. However, he says, see section A above, again, another example of the judge expressly referring back to the earlier parts of the judgment. There was publicly available information that the owner was Twinkle, etc., etc. So, I mean, the essential point, I'll allow you to read this on another occasion if you'd like to, but the essential point the judge is making is that this would have been a rather inept fraud because it was publicly known that Twinkle owned the general partner. And it was also known that Mr. Falaschini, who was another leading light in XY and indeed a defendant to the claim in his own right, was a director of it, and you could find that out. So it would be a bit silly if you were going to defraud all these investors into investing in a fund by concealing your connection to it for the fact that the general partner is owned by Twinkle to be public, and for Twinkle publicly to be run by Mr. McCartney's right-hand man. I think we can then move forward, please, to paragraph 1215, final sentence, page 354. And again, the judge makes it clear that you need to look back, in this case, at section D, we then come to the conclusions at 1229, page 357. Then about four lines down, he makes the point that the claimants were aware of Mr. McGarney's significant connection to the fund, in that he was the entrepreneur behind it and he was the owner of the general partner. So again, it's that twin pillar shorthand, but any fair reader of the judgment would understand that what he's doing there is simply a shorthand for all of the findings that have been made earlier. Then, of course, at 12:30 he makes the point, which is one of the points I made yesterday, is that the claimant's alleged obsession with independence was completely overblown. In my submission, it's basically part of the reverse engineering of the claim that the judge adverts to it earlier in the judgment. 1232, final sentence, the judge makes the point that they like the man and they like the strategy. That was the whole point. And then at the end of 1233, the judge notes, final sentence, a forensic point that all of these protestations about knowing nothing about Dr. McGarney and Mr. McGarney's connection to the fund only surface upon receipt of the particulars of claim, despite the fact that obviously when the balloon went up there was a whole lot of very fraught interaction between the parties. If we could then please move forward to paragraph 1282, page 369. Now, my learned friend would say, well, this is in section J, dealing with the alleged conspiracy, but you have my submission that it's all interrelated, not least because the whole point of the conspiracy claim was just to catch extra defendants, because the unlawful means alleged in the conspiracy were all the same as the underlying claims. But the judge here makes the point that he doesn't consider that there was, in fact, anything that could properly be considered to be a facade at all. That's important because, in the most general sense, the claimant's whole case below was that there had been this sinister facade to portray, positively to portray the Skew Base Fund as being unconnected to Mr. Megani, when in fact it was. So that's the facade, and the facade is relevant not just to the conspiracy, obviously, but to the alleged independence misrepresentation. And then at 1283, the judge goes on to explain that investors such as the claimants would have understood what was going on. And then towards the bottom of that page, in fact, any investor who didn't know, who was already behind it, could ask a simple question. But here, the claimants didn't ask that question because they had been told who was behind the fund and who owned the general partner. So it's those twin pillars. Again, then at the top of 1284, the judge refers to the specific aspect of the alleged facade that featured heavily in the claimant's case, concerned the role of Twinkle. So what the judge is here doing is addressing the case that my learned friend put, and in effect the case that he spent much of yesterday putting to you. So whatever else one could say about the judgment, it is not a fair criticism to suggest that the judge overlooked anything that the claimants put, as I will endeavour to show more fully today. And 1285, the judge addresses the point again pressed on you yesterday, that the Twinkle isn't identified by name. But he says, well, it's not a facade. And in fact, as the learned judge explained in section F of the judgment, if I can use the horrid colloquialism, it was cock up, not conspiracy. So the reason, I don't have time to go through it all, but the reason that Twinkle wasn't named was actually just an error by the in the drafting. All the drafting was done by DLA, and the Skew Base Fund waived privilege over the back and forth. And once one went through all of it, it was obvious that the lawyers had basically not done the change, had not made all the changes they should have made. And so there was nothing sinister about Twinkle being omitted. It was just, it was actually intended to, even though it wasn't obliged to be in, it was intended to be in. The lawyers just forgot when they were doing the changes to put it in.
That's the lead up to 829 and 835, 836.
And I'm sorry, I know you've all read this judgment really carefully, and it's
it's
a bit boring for me to go through it, but I feel I must.
I happen to have done that cross-referencing myself, and I mentioned it in case it helps anybody
Yes, my
else.
lord, exactly that. And then we look at and at 1286, the judge makes this sort of broad summary that there wasn't any facade. So if there's no facade, there was no conspiracy at all. And then at 1295, the judge is dealing with intention to injure. You can just please read that for yourselves. This is obviously relevant to a point that you were discussing with my learned friend yesterday in relation to the way that he puts his prescriptive or positive duty. I think he was trying to suggest that this was all part of the duty which is well established in corporate law, that a company director must act in what he considers in good faith, or she considers in good faith, to be the best interests of the company. I'll have a few words perhaps about that later, but the simple point is, even if you don't agree with me that duty, which wasn't pleaded below, wasn't put below, and I'll explain that in a minute, but even if that duty is allowed to be paid in aid here, it wasn't breached, because the judge basically makes findings that there was no bad faith of that sort. So it may well have been negligent not to refer to it, but it wouldn't have been a breach of the duty that's considered in, which is now in section 172 of the Companies Act. But see also, while we're in this part of the judgment, paragraph 1257, where the judge acquits Mr. Magani of dishonesty.
Sorry, 1257.
1257, my lord,
Yep.
page 364, where the judge acquits Mr. Magani of dishonesty in connection with the dishonest assistance claim. Now, as I say, it wasn't put in this way below. There was no reliance on the duty that we're discussing, but I just highlight that the very simple answer to it is that even if it had been put, and even if it applied, which I don't accept it does in this context, the judge's factual findings would dispose of it in any event. Before we leave the first pillar, could we please just turn up paragraph 777, which is at page 241 of the This is in section E of the judgment, which deals with the offering documents. I don't have time to do justice to the judge's careful description, but section E sets everything out that you need. I'm not going to take you to the offering memorandum itself because it's all in here. But 6.2 was a section you were taken to yesterday. And in the second paragraph, it makes it clear that the general partner shall have the broadest powers to act. The general partner is responsible for laying down the investment policy of the compartments. It may carry out all acts of management and administration on behalf of the fund's compartments. The essential point about this structure is that Yes, VP as a service provider has an important role, largely because the regulations say that you've got to have a VP. Just pausing there, why do the regulations say you've got to have a VP when you're setting up a private label fund? Well, obviously, it's because you can't have a completely private label, or the legislature won't allow a completely private label fund because you need some sort of independent involvement. That's really what is going on. But the general partner has overall responsibility, including for the investment policy and all acts of management and administration, and it appoints the VP entities to do the various tasks that they do. So it's absolutely essential part of the machinery. And as we saw just a moment ago, the judge found that these particular claimants would have understood all of that. Paragraph 781 sets out the fee provisions.
Where's the reference to the AIF manager appointing an investment manager?
The investment advisor.
Investment advisor.
Someone will find that quickly for me and let you know.
Is that 6.4?
Yes, that's
On page 243 or 178 of the judgment, with the consent of the fund,
which is
under its supervision, the principal of the AIFM may appoint a delegate.
Yes, that's the investment manager, not the
Investment manager.
advisor.
Yeah.
Twinkle, the judge found, was the investment advisor,
Yes.
which is appointed by the portfolio manager, I think, is the point. But I'll come back to my lord in a moment.
And 6.3 talks about the AIFM delegating its performance of various operations.
Yes, I believe it's in the appendices. But somebody will.
It's obviously a defined term because it's referred to in 6.8. Investment advisor, bottom of page 244.
Mr. Fenimore corrects me. There's not a specific clause that says it can appoint one. There's just various references. It's a defined term, and there's various references to the investment advisor in the document. But obviously,
What does the definition say? Does the definition identify that it's going to be a delegation of powers of the portfolio manager?
there isn't. I don't think there's actually a definition. This is part of the problem in the drafting.
Right.
Can I come back to that point generally, so that we give you the full.
I mean, the judge obviously explains in detail how the structure worked and was intended to work. Where I know he refers to this point, but I can't remember whether he relates it to the offering memorandum.
781 sets out the fees. Paragraph 781 of the judgment, that is. At 9.3 makes the point that the AIFM is entitled to an annual fee, but it's paid by the general partner out of the general partner's own fee. And then 9.4, the fees of the investment manager and the investment advisor, if applicable, will be borne by the general partner out of its own assets. And again, it's all, everything goes to the general partner, and then the general partner is obliged to pay any service providers that there in fact are.
So just to go back to the point my lord made, the judge deals with the general structure at 798, identifying that another service provider is an investment advisor to the portfolio manager. This is at page 258.
Exactly.
And then 802 says the evidence shows the structure of the Skew Base Fund was a typical structure and identifies the features. And then subpara 7,
Exactly.
VP Lux engaged Twinkle, entitled to be paid, although Twinkle was not identified by name as investment advisor in the offering memorandum. Section 9.4 referred to the fees of the investment advisor if applicable. That's as far as what gets anything out of the
Yes.
So
the
we
offering
get
memorandum.
so we get a capitalised term, but no actual definition of the capitalised term. Yes, I see.
Thanks.
But let me not focus on this point of detail about what the offering memorandum says. The real point of substance is the point that the judge makes on a number of occasions, which is they knew that this was a Megani product, vehicle, whatever you want to call it. And the whole point was that he and his team should be running it, and in particular should be running the investment side of things. Which would be sufficient for my purposes, even without there being as it were, a grounding in the offering memorandum for that. Because, as the judge says, the logical consequence of that is that they get the lion's share of the fees, one way or another, and that is what happened. I won't spend time going through the particular appendices for the different compartments that are relevant to this case. You have them respectively at tabs 8, 9, 10 and 14. But as you'll have seen, the way that the offering documents worked was that there was a common offering memorandum and then a specific appendix for each of the compartments. So that's what I want to say about the first pillar. Can I move then please to the second pillar? That's what the judge calls for shorthand behind the fund, but basically means the claimant's knowledge of Twinkle's role in the conception, initiation and operation of the fund and its investment strategy. We saw the point yesterday at paragraph 1200 that one of the reasons the judge fixes these particular claimants with knowledge of how all this works is because obviously MDM and his father, LDM, set up Charm and its various AIFs. And if we could please pick it up at paragraph 787 of judgment, page 256. This is section F where the judge talks about, and it's a very important section obviously because it feeds into the conclusions in section H. But at the end of 787, the judge highlights right at the top of this section that an important feature of the claimant's case is that there was concealment of the role that Twinkle played in relation to the operation of the fund and of its connection to Mr. again, we've got those twin pillars. But my point is there could be no possible doubt that the judge was completely aware of the claimant's case and that he was squarely addressing that case. And then at 794, the judge explains in the first sentence, a fund is the initiator's product. I won't read the rest of 794, but that's the upshot. 795, the initiator, Mr. Megani in human form, Twinkle in corporate form, selects the service providers and negotiates their fees. That's obviously important because once the appellants understand how this all works, they know that far from this being some kind of VP fund, the whole point of one of these AI or RAIFs is the initiator appoints those people and they're effectively just service providers.
Do we need the paragraph 790 further up, that the Luxembourg financial regulator definition of an initiator
Yes.
includes someone who determines the conduct of its activity?
Yes.
It's not just the evidence from Mr. Conrad, it's essentially the official position of the regulator.
This is why Luxembourg is this private label fund. I think they're also sometimes called white label funds. But yeah, that's why it's the centre for these in Europe, because they've got a whole architecture for it. At 798, first sentence, the judge then again adverts to the investment advisor. And then he makes the point, which again would have been obvious to these claimants, that if the initiator isn't the portfolio manager itself, which it wasn't in this case for particular legal reasons, then the initiator or a company linked to it is invariably the advisor. And of course, that has to be the case, because the whole point of these funds is they're effectively in-house funds for businesses like XY. You're not allowed to sell them, promote them generally, hence all this talk of reverse solicitation in the papers. They have to come to you, and so all of the investors in these funds, or most of them, are existing clients of the initiator. That's how it all works. Because obviously, these extremely sophisticated, wealthy people wouldn't be entrusting tens of millions of euros to people that they didn't know really well and whose advice they didn't value. We then have at 799 the point that really follows, as a matter of common sense, that where the initiator acts as advisor, the advisor receives more by way of fees, often a lot more than the portfolio manager. Indeed, it was very normal for the initiator, whatever role it had in relation to the fund, to expect to receive a major part of the fees paid by the fund. The initiator normally receives whatever is left over from the global fee after all the service providers have been paid. And then if we skip a sentence, if the initiator did not have the potential benefit of being well paid for all of its work and risk, there would be no commercial incentive for them to set up a fund at all, and the whole industry, not just in Luxembourg but across Europe, wouldn't work. And this is not some technical point ultimately. These claimants obviously understood that the lion's share of the fees would be going to the person who created the fund and who was in fact running the bit of it that made or having a very close involvement in the bit of it that made the money. And then we have 802, which my Lord has helpfully already drawn attention to, and in particular, I would point to sub 5 and sub 7 as being important to the way that the other side put the case here. And then at 803, there's the judge's point that this was just not off the side. There was no intention for it to be concealed. And then in 804, the judge makes the point that there's obviously nothing unusual in Twinkle being connected to Mr. Megani. That was the whole point of it. And indeed, at the outset of discussions in setting up the fund, the assumption was that XY would be the initiator, but then it changed to Twinkle, as the judge explains in this, or summarises in that paragraph. Essentially because, as the judge said, elsewhere in the judgment, Mr. Megani wanted, in the event, to keep the two lines of business separate. And there were, in fact, separate teams and offices. And obviously when I'm talking about Mr. Megani being sort of human initiator, once the thing's up and running, obviously it's not just Mr. Megani. In fact, he had very little to do with it in day-to-day terms. There were obviously other people doing all of the work. Mr. Negro in particular, who you see referred to in the judgment, was the critical person in charge of the investment side of things. And there was some suggestion yesterday that Twinkle was a complete ingenue when it came to setting up investment funds and running the investment strategy for a fund. Well, I mean, yes, but so was Hargreaves Lansdowne PLC when it was incorporated. The human beings that populate Twinkle, such as Mr. Negro, whose CV you can see summarised at the beginning of the judgment, obviously those people are hugely experienced fund operators and investment managers. It frankly beggars belief that the appellants would have invested 102, however fabulously wealthy you are, you don't invest 102 million euros with a fund that you know nothing about. That's the essential point. And of course they knew that it was Mr. Megani's team. I don't have time to go through it now, but 822 to 829 is really the discussion of the point I was making earlier about there being no intention to conceal Twinkle. On the contrary, it should have been included, and it was not included because of an error.
I mean, of itself, that doesn't answer this claim.
No, but the rhetorical point was made yesterday. Well, there is an answer for why it's not actually in there, and that's explained in 822 to 829. The important point was that below, it was all put on the basis that there was a sinister facade to conceal Mr. Megani's connection, because that's of course how they get the no conflict rule at all, is through Mr. Megani. And then at paragraph 836 and 837, these are the conclusions, again I don't have time to go through it all, that the judge makes about there being no obligation for the offering documents to identify Twinkle as the investment advisor or set out the fees. And his lordship explains how it had been the claimant's case that this was all illegal, but they abandoned that. And at 837 at the final sentence, it's not out of the ordinary for the advisor and its fees not to be stated in the prospectus. But frankly, why does it need to be stated? It might change. The essential point is that the general partner gets everything and can then disperse what it receives as it wishes. Section F3, the judge addresses the various contractual arrangements in relation to the service provision side of things. I'm not going to go through all of the rest of section F in detail, but if we look at the bottom of paragraph 841, final couple of sentences, of course the fees that are paid to Twinkle are greater than those paid to VP, but there's nothing unusual about that. It's very normal for the initiator to expect to receive the major part of the fees. With respect, that's blindingly obvious, otherwise why would you bother setting up a fund at all if you weren't intending to make money out of it? And then please, if we move on to paragraph 859, we see the judge recording there was nothing unusual about any of this, and he elaborates on that in 860 to 862. Mr. Conrad's evidence was basically completely accepted by the judge. And then at 863, the judge makes the point that I made a moment ago to the court about how it's very common in this private labour fund industry for investors to be drawn from the initiator's client base. And it's normal for the initiator to get substantial fees if investors make investments. Nothing at all unusual about it. And of course, these appellants are fixed with all that understanding, because this is one of the things they do for a living. Then at 867, the judge summarises all of this to say there's nothing unusual. And that is one of the reasons to reject the conspiracy, because there just wasn't a facade. 869, he makes the point that I referred to earlier about how there is not a single communication between claimants and VP. And the reason for that is because plainly they did not think that VP was running the show, doing the heavy lifting, as my lady summarised it yesterday. Obviously, it's the Megani vehicle that's doing that. again, I don't have time to go through it in detail, but yesterday my learned friend was making or resurrecting the complaint he made below about how, in fact, Twinkle was the real portfolio manager. The judge deals with that at paragraph 881, 883, 885, 887. The way the judge summarises the claimant's case is the notion that Twinkle was the de facto portfolio manager, and he rejects that. As he says in 885, Twinkle was the investment advisor. Then we have paragraph 907 on page 284. Sorry, 909. Initiators set up AIFs because it gives them a significant offering to their existing new clients. And obviously, and 910 indeed, the judge makes the obvious point that ultra high net worth individuals invariably want to know the people that are looking after their money. Then at 912 he comes back to the point that at no stage did these claimants ever contact BP. Quite a nice summary at the end of 912. The point I was making a moment ago that ultra high net worth individuals do not invest huge sums of money in an unknown fund run by people they've never met from a small company in Luxembourg without ever having discussed any of it. Then at the end of section F, at F11, paragraph 962 and following, that's page 296 of the core bundle. The judge runs through the connection, and in 963, the connection, sorry, 963, third sentence, there was no dispute that Twinkle had significant involvement in the operation of the fund in its capacity as investment advisor. The claimant said that they weren't just that portfolio manager, but the judge had rejected that. No substantial dispute about the existence of connections, etc., etc. The reason I highlight section F11 is just again to highlight that the judge was plainly aware of the way the case was put by the claimants. As we'll see in a moment in relation to grounds 1 and 2 of the appeal, the appellants come close in their written arguments, not so much yesterday to be fair, to suggesting that the judge was unaware of all these points. I mean, plainly he wasn't. He addresses them squarely. just that he reaches a different answer to the one that the claimants were urging upon him. Can we just finish this off by having a quick look about what the appellants knew about the Skew Base Fund particularly, and I think we can pick this up at 3.3 paragraph 337 of the judgment, which is page 142. And this is an example of the judge summarising what was said to MDM, and in particular, because I'm focusing at the moment on this second pillar, there's a discussion of the second pillar points. It's Mr. Megani's project, and he was the entrepreneur behind it. Sorry, 337. My friend referred to this. This is the first time that MDM is told about the fund. And paragraph 337 is quite a good example of the judge referring forwards as well as backwards in the judgment. This really is quite a, with respect, quite a carefully constructed judgment. If we could please move forward to paragraph 442. This is referring to a meeting on the 2nd of March. And again, my old friend referred to this yesterday. But again, the judge is looking forward and anticipating Section H. And he says, I consider below whether they were told about the connection and who they were. And one of the reasons is that they were told about it on the 2nd of March. And then in 443, he makes the point that in the middle, the idea of doing all this through a fund was attractive, not least because it would avoid the need for multiple investments. The point about that is, as I said yesterday, there were really two big draws for the appellants, one of which was, instead of Mr. Nutso having to do lots and lots of individual trades with XY on a sort of rolling basis, just buy shares in a fund that did that. And then at 444, the judge makes the point that the fact that Mr. Facchetti, in an unguarded moment of cross-examination, explained that Mr. Megani had chosen VP indicates that he did appreciate at the time that Mr. Megani was the person who was in charge of it all. Mr. Facchetti is the right-hand man to MDM. And then, if we please move forward to paragraph 749.
Sorry, 2479.
Sorry, my lady, 749.
749,
And
sorry.
this is on page 229. And we say, I'm not going to read them all now, but paragraphs 749 to 754 are critical. especially paragraph 751. 751 is the paragraph where the judge finds that Mr. Nutso regarded the Skew Base Fund as synonymous with XY. And that's no doubt the reason why my learned friend is so keen to say that this doesn't get incorporated into section I of the judgment. Well, that doesn't work for the reasons that I have explained. Just before leaving the judgment, should pick up a point that's made at paragraph 43 of my learned friend's skeleton. That's in Core Bundle, tab 13, page 449. Sorry, page 450. And the submission is made that Mr. Megani's companies were, in this way, and unbeknownst to the appellants, being paid twice in respect of the appellant's investments in the Skew Base Fund.
Sorry, whereabouts in the paragraph is that?
It's the last sentence, my lord, sorry.
Oh, I see, yes.
That is a remarkable submission, because it's quite ironic, but it's remarkable. I'm not going to go through it all now, but if one looks at paragraphs 596, 606, and 613 to 622 of the judgment, that submission is flatly inconsistent with the judge's factual findings. The reason it's ironic is that some of the material that the judge bases his conclusion on are emails in which Mr. Nutso is basically complaining about XY or Mr. Megani being paid twice in respect of the appellant's investments in the Skew Base Fund. And the judge finds that the fact that Mr. Nutso was pressing Mr. Megani, saying, well, hang on a minute, I don't really want to pay you, Mr. Megani, twice, was one of the reasons that Mr. Nutso obviously knew that Mr. Megani was behind the fund, because obviously if the fund was completely separate from Mr. Megani, there'd be no element of being paid twice. But it's quite remarkable for this to be relied on in the skeleton argument here, because the judge's conclusion is the opposite, that they did know that there was this element of double payment, and they raised it and they tried to get a reduction. And then 622 is the conclusion. I consider that this email exchange provides evidence that Mr. Nutso knew of the connection prior to sending his questions, that Mr. Megani was not seeking to conceal the connection, and that the connection was mentioned when the questions were answered.
I'm so sorry, which paragraph, sir?
So that 622, my lord, is the judge's conclusion on those email exchanges. But the point is, so far as my learned friend's submission is concerned, is that the opposite is the case. And indeed, that's one of the reasons why the judge's conclusion was the right one. So, the appellants know that the fund is a Megani product. He and his company are the initiator. That was the whole point, so far as they are concerned. They liked the strategy, they liked the man. What they were buying was a Megani wrapped, and they wanted to continue doing that strategy in a fund wrapper rather than in lots of individual trades. They well knew that Mr. Megani's company, as the initiator, would be closely involved in operating the fund and its investment strategy. That was the whole point. And they knew that as it was Mr. Megani's product, he would ultimately receive the benefit of the lion's share of the fees that are paid by the fund. That was the whole commercial point of the arrangement. They appreciated that, not least because that's how their own Luxembourg AIFs work. And so, if we return to paragraph 27 of my learned friend's skeleton, which is the crux of the appeal, page, it's core bundle, tab 13, page 444. So there was concealment, it is said, of the amount and or proportion of fees that companies owned and or controlled by Mr. Megani would receive. Well, no. That
Wait,
was...
sorry, go on.
Please, my lord.
I mean, when you say no, and I stopped you going further, which might have fleshed it out, but I mean, in one sense, it's true that all this detail was not revealed. So your case is the extra detail didn't need to be disclosed.
Exactly. Because, well, you're right, in one sense that's right. And part of the problem with paragraph 27 is that it's another example of the sort of reverse engineering that would underlay the whole claim at trial. Because obviously what my own friend is trying to do is to try and find things that he can say weren't disclosed, in order to say, in paragraph 27, here are the critical things that should have been disclosed, whichever way one analyses the case. But again, one needs to look at the substance, not the form, because even in the way this is put, the amount of fees that companies owned and or controlled by Mr. Megani would receive, well, in one sense, my lord, I'm completely right to say that was disclosed, because they knew that 100% of the fees were going to a company, the Skew Base company, that was owned and controlled by Mr. Megani. So one needs to be a bit careful with the way it's put. But I don't dissent from your lordship's point of substance, which is, well, in one sense, they weren't told about the amount of fees in relation to Twinkle, but in my submission they just didn't need to know that. And there's no suggestion that they ever asked about any of that, and it's absolutely clear that if they had asked, they'd have been told about that. 27.2, the closely related issue of the role of Twinkle, which was receiving substantial fees for advising the portfolio manager, and further, that Twinkle was closely involved in the selection of investments. Well, I really struggle to see how this sub-paragraph makes any sense once you read the judgment holistically. Unless the only point that's being made is the entirely semantic point about the name of the company, because they thought it was XY and in fact it was Twinkle. But the critical point, so far as they were concerned, is not the name of the company, which particular corporate entity was involved. It's that it was a Megani company. And as I said to the court yesterday, it's because it's a Megani company that we get into the question of fiduciary duty in the first place. So we can't just then forget the substance of that when we look at the question of informed consent and the like. 27.3.
Just before you get to 27.3, I think another element of what was being said yesterday and is in here is the unregulated bit. So it's not just that you've got an entity doing this job and getting paid for it. It's probably going too far to say that aspersions were cast on Twinkle, but at any rate we're told, inexperienced, unregulated, that had to be disclosed.
Well, no, because we saw in the passages of the judgment that we were looking at that there was this whole case about how there were breaches of the Luxembourg AIFM rules, and that was all abandoned. And Twinkle, as a matter of law, didn't need to be regulated. But the foundation for my friend's complaints about Twinkle as a sort of newly incorporated, unregulated entity, in my submission, failed as a matter of substance, because they were looking to the people behind Twinkle, or in Twinkle, that is Mr. Megani and his team, not at the shell itself. In any event, I'll come on to this when we discuss ground one in a moment. What my learned friend was saying yesterday seemed to me to amount not to an allegation of breach of fiduciary duty, because what he was saying is, well, there might be some duties to provide all sorts of information, but they wouldn't be fiduciary duties necessarily. There might be tortious duties of care or some other duty, but I'll come on to that. But the point
just to anticipate what you're going to come on to, you say in this respect, if an advisor ought to be telling his client that somebody involved in the management of the money had some flaw, that's not something going to conflict of interest.
Precisely. There might be a contractual or tortious or some other duty to say that. But the point of substance here is, of course, they, if we put aside the semantic point about the name of the company, of course they knew all about the role of Twinkle and its receipt of substantial fees and its close involvement in the selection of investments, because that was the whole point of it. And then the final one, 27.3, the fact that Twinkle was owned and controlled by Mr. Megani. Well, insofar as that relates to the ownership of the general partner, that's just utterly unsustainable. Because the judge found that they undoubtedly knew that he owned the general partner. But the judge also found that they undoubtedly knew that he owned the initiator. And again, that's the whole point. They might not have known that, in fact, the initiator was Twinkle rather than XY. And indeed, paragraph 751, Mr. Nutso believed that it was XY that was doing that. But again, that's, in my submission, a semantic point. One needs to look at the substance. What they knew and understood was that Megani was behind the initiator. And again, that was the whole point from their perspective. If I may, can we move on then to some law? I think we can put the judgment away. So that was my first heading, important background facts to judgment. Second heading, general principles. These can take up Authorities Bundle 4, tab 39, Popplewell. This is obviously the most recent Supreme Court decision that's directly relevant to this appeal, and in that sense we probably don't need to go much beyond this case. Please could we pick it up at paragraph 68, which is 1703 of the bundle. And we see in the final sentence where the court are discussing the no profit and no conflict rules, that the profit rule is the twin sister of the conflict rule. There's no suggestion here of the third type of rule that's prayed in aid by the appellants. And then if we turn over to paragraph 72, in the final sentence, the point is made that the only defence to breach of the profit or conflict rules is that the principal gives its fully informed consent. In that sense, there's not a duty as such to obtain informed consent. However, note that there's a reference there to Lord Briggs's judgment in Ricadza at paragraph 40. We've got that in tab 37, page 1568. Where Lord Briggs said it's not a defence for someone who didn't in fact obtain consent to assert that he would have been given it if asked. It asked whether the fiduciary would have made the profit if he had done his duty and asked his principal for consent. So even Lord Briggs talks about it in terms of there being a duty to obtain informed consent. If one is being completely strict, there's probably not a duty as such. It's really the point that my Lord Justice Newey made yesterday. You can describe the duty as a duty not without the principal's informed consent to put yourself into a position of conflict.
But when Lord Briggs is expressing the no profit rule, he puts it that way. When he comes to the twin, he doesn't. I mean, if you go back to paragraph 68.
Yes. However, if we turn on, my lord, to paragraph 89 at the top of page 1709. The court is here, as one sees at the bottom of the previous page, referring to the famous passage from Mothyew, which we looked at yesterday. And I think one of my Lord Justice Newey's questions was, does without the informed consent of his principal apply to all the limbs? Well, that's certainly how the Supreme Court read it in paragraph 90, which I think is the point that my Lord was just adverting to. Accordingly, if a person is fiduciary, he mustn't put himself where there's a conflict subject to informed consent. In addition, or perhaps in consequence, he mustn't receive a profit. Again, subject to informed consent. So it's clear that the Supreme Court, to answer the question that your Lordship posed yesterday, say that the informed consent applies across the various conventional fiduciary duties. Then, if I may ask you to turn up paragraph 110 on page 1714. And about 2/3 of the way down, the court says no obligation of loyalty arises. What they're...
Sorry.
I've lost.
I'm sorry, my lady.
Oh, I've got it.
Yes.
Sorry.
Yes.
What the court is here discussing is the example of the wine waiter or the sales assistant who's asked for an opinion about what wine should you have with your meal, or does this guest look nice? And what they're saying is, well, obviously no fiduciary duty arises. Such a commercial transaction or arrangement in which one party has a personal financial interest which is known to, or apparent to the other party is not one in which an undertaking of undivided loyalty and altruism can readily be implied or recognised by equity. And I do draw attention to that passage, which will come on to Medstead in a moment. But I'm obviously not saying that this case is in any way comparable to the wine waiter example. But logically, if, as the appellants in this case did, know everything they need to know before the transaction starts happening, logically you could say, well, why is there a fiduciary duty? Because it would be a bit weird to say that there's a duty to avoid a conflict which has been, as it were, pre-waived by the client. And of course, in Medstead, one of the conclusions, and it's important it's only one of the conclusions of the court is that in that case the duty just didn't arise because the client knew all about it. So one potential way of analysing it is to say, well, where the other party knows all about it, you can say the duty doesn't arise.
That wasn't the judge's finding in this case.
No.
I mean, the analysis of the wine waiter is no duty because the customer is not entitled to expect him to be loyal to the customer as opposed to be loyal to his employers and flog off the duff wine if they need to get rid of it. But that's all about whether there's a fiduciary duty, not about the scope of the informed consent.
And in our case, the judge did the conventional thing of saying, well, there was the no conflict duty, which applied in full. There was no we'll come on in a minute to this, there was no narrowing or moulding going on. He just said, well, there is the no conflict duty, it applies in full. The only question then is there informed consent? I just point to this because sometimes, in some cases, Medstead is an example, people have analysed it as the scope of the duty being reduced by reference to what the other party knows.
I mean, in this particular point, the wine waiter is not saying the duty is reduced. There's just no duty.
No
You're
duty.
not in a fiduciary situation at all.
Exactly. If we could turn on to paragraph 209, please, which is on page 1740, 1740.
209.
Yes, 209, my lady. And really it's 209 to 226, which is the critical passage for our purposes, and which I'm sure the court will want to consider in detail. I'm not going to read it out to you. Can I just highlight a few points? Paragraph 209, second sentence. Disclosure places the principal in a position where he can take an informed decision whether to affirm the transaction. So the point of this is to make an informed decision. At the final sentence of paragraph 210, it's explained again that you can avoid the liability if there's informed consent. And then at 211, it's well established that it must be a fully informed consent, and it has to be all material facts, and I obviously highlight material.
Material to what, do you say? I think it said against
Material
you,
to
it's
the
material to the investment advice that's being given. Whereas I think you say, but tell me if I'm wrong, it's material to the conflict.
Exactly. That's my submission. It's material to the conflict. It's obviously material to the conflict. Otherwise, and this is a point I'll come on to in a moment when we discuss ground one in more detail, otherwise you start turning negligence into fiduciary duties. That's really the whole point that Professor Finn is making in that article that my lord drew attention to. I mean, plainly, it doesn't mean material to the transaction in every sense, because otherwise you really would be massively expanding the scope of fiduciary duties.
So certainly it's become axiomatic in English law, though I don't think every other system of law that negligence is not breach of fiduciary duty.
Exactly. The US and Canada take a very, and Professor Finn discusses all this in that paper and elsewhere. They take a different view, but in England and Australia, the rules are the same, and plainly, it means material to the conflict. Now, it's right that they say at the end of 211 it's not enough to place the principle on inquiry, but that doesn't mean that the court unrealistically closes its eyes to what the principal in fact knew. So just because the court is here saying it's not enough to place the principle on inquiry, that doesn't mean that the court ignores the fact that the principal knows a whole bunch of things.
Yeah, the whole concept of being put on inquiry assumes that there is no actual knowledge.
Exactly. And we see that, I think, at paragraph 213, there's a discussion of the Imperial Mercantile case. And at the top of page 1742, towards the end of the paragraph, the passage begins, as the decision illustrates. About 9 lines down. Now, the whole point of Imperial Mercantile was that the Stockbrokers Commission was not the usual Stockbrokers Commission, it was some enormous other commission. But the Supreme Court is here saying that it might have sufficed if the commission received had been the usual Stockbrokers Commission, as the information which had been disclosed would then have been sufficient to enable the directors to form an accurate idea of their fellow directors' interest in the transaction. So, one does have to have regard to the principal's understanding of the sort of structure or transaction in issue. There are obvious, in my submission, there are obvious parallels here to Mr. Justice Jacobs' findings in respect of the appellant's knowledge of how private label Luxembourg AIF structures work. Because the reason that if it had been the usual commission, then the directors would have been fixed with the knowledge is obviously because the directors would have known what the usual Stockbrokers Commission was. In any case, as the court says, well, it depends on all the circumstances. And so my submission to you is that all the circumstances obviously includes what the principal knows. It certainly includes what the principal and fiduciary know that the principal knows. At paragraph 215, there's then a discussion of an angel. Which is approved. And the important point about an angel in my submission is between B and C, Legate J concluded that the information which had not been disclosed as to the precise amount of the payments was, quotes, not material so far as the plaintiffs were concerned, close quotes. And I would underline the so far as the plaintiffs were concerned. So it's not just thinking about all of the circumstances of the case, which obviously includes what the principal knows. You've also got to ask, that's why the claim failed in Anangel. What is material so far as these particular claimants are concerned? And as the Supreme Court goes on to say, what amounts to disclosure of all material facts depends on the circumstances of the particular case. Not every fact which could be disclosed is necessarily material. And the significance of the payments in Anangel being reasonable was that the disclosure of their existence gave the ship owners, in the circumstances of that case, all of the information that they required in order to understand the nature and extent of the interest. Just to pick up my Lord's point a moment ago, in my submission, that final sentence supports the point that the question of what is material obviously means what's material to the conflict. And so what the court needs to do is what in the circumstances of the particular case did this particular principal need to know in order to understand the nature of the interest. And then 226 letter on page 1745, letter D, in order to negative such a breach, what is required is disclosure of all material facts. So the Supreme Court is looking at this in terms, just like the judge did, of there's no conflict of duty, there's no moulding or narrowing of it, it applies. The only there's a breach if there's no, but there's only a breach if there's no informed consent. And then they make the point again by reference to Imperial Mercantile and Anangel at the end that this isn't every fact, it all depends on the circumstances.
That passage between B and C does suggest that it's not being looked at in terms of any obligation to make disclosure. Disclosure is required as a condition for excluding the law's remedial response
Precisely.
to the breach of duty.
And when in some of the authorities, including Lord Briggs no less, you sometimes see people talking about the duty of disclosure. The point, as my Lord says, is actually the disclosure is how you avoid the breach. There's no actual duty of disclosure. And obviously once one understands that, my Lord, I mean, there are various reasons in my submission why my learned friends submissions about the prescriptive and positive duties fail. But that's one of them, because if there's no duty to disclose at all, and if on analysis, as the Supreme Court is saying here, the only duty is the no conflict duty, but it can be, any breach of it can be waived by informed consent, then my friend's case in that regard doesn't get off the ground because there isn't a duty at all. So he needs to find some other basis for the duty to disclose. That's just the converse, I think, or it's just a different way of saying the same thing that Professor Finn is saying in the article that my Lord Justice Newey drew attention to. Could we please turn to, unless there are any further questions on Hopcraft, in a sense that's the beginning and end of...
And we've obviously got a lot of these cases in the bundle. I envisage you all thinking that we'll take this as shorthand rather than going through Imperial and...
Yes.
Yes.
And obviously I rely a lot on Imperial and Unangel,
Yes.
but for present purposes I don't think I need to do more than show you what the Supreme Court thought about those cases to make the submissions that I'm making, my Lord. So we can put away bundle 4. Medstead is authorities bundle 3, tab 31. Obviously approach this diffidently, given that my lady was in the case, but if I could summarise in a sentence what we say about Medstead, it's hard to see how our case is distinguishable from Medstead. In fact, our case is even stronger than Medstead. Because in our case, well, actually, I should probably just remind the court, in very brief outline, of the facts where Medstead. Basically, what happened was an introducing broker, Medstead, introduces its wealthy and sophisticated clients to an investment house called Collins Stewart for the purposes of enabling the clients to trade contracts for difference with the investment house. And the trades were leveraged, and so the clients had to put up a margin of a given percentage of the value of the CFD. And it's obviously, of all the cases in the bundle, it's one of the closest to our case in context. The sorts of underlying investments in the Skew Base Fund that the Appellants complain about are not a million miles away from a contract for difference. They are, in effect, gambling on moves in the equity markets. In the case of Skew Base Fund compartments, it was by reference to indices, but it's a very similar context. And the clients paid the investment house, they paid Collins Stewart two things. One, a commission, which was 0.7%, and two, a financing charge of 6.2%. And the clients knew that the broker that introduced them, Medstead, would be paid commission by Colin Stewart. So the clients knew that that Colin Stewart would pay both a share of its commission and a rebate of the financing charge to the broker. They just didn't know how much. In fact, Colin Stewart paid Medstead 0.25% of the commission and 4.5% of the financing charge. And the conclusion of the Court of Appeal was that the broker's failure to explain precisely how much it would get of the fee that was being paid to Colin Stewart was not material, either because there was no duty to explain that, or because there was no breach of fiduciary duty in not explaining it. And so you can see it at paragraph 26 on page 1071. In the final sentence.
I'm sorry, which paragraph?
It's 26, my lady.
Thank you.
The final sentence. This is summarising the conclusions of the judge below. Was that Medstead, the broker, was under a duty. And
Sorry, I must be reading the wrong place.
I'm sorry.
Which paragraph are we in?
It's paragraph 26, Medstead,
I see. Yes, I see.
final sentence. And that's the judge's finding. There's a breach of fiduciary duty.
I still must be
Still
reading
not
the wrong
right
place. Paragraph 26, last sentence. I must be reading the wrong thing.
I'm so sorry. It's my it's my fault, my lord. It's not the last sentence. It's the middle passage.
Oh, I see.
His conclusion was paragraph.
Aha.
I do apologise.
Yeah.
So that was the judge's finding, that failing to tell the precise split to the client was a breach of fiduciary duty. The Court of Appeal agreed, if we turn over to the very final part of paragraph 32, the final subclause of the sentence, to my mind, that gives rise to a duty which can legitimately be described as fiduciary. And then 33, it said, that's not the end of the matter, because one still has to ask what the scope is. And then paragraph 34, final two sentences. The clients knew that Medstead, that's the fiduciary, was being paid commission by Colin Stewart. What they did not know was the amount. The question to my mind is therefore whether it was in the scope of Medstead's duty to inform them how the commission was to be divided between itself and Colin Stewart. So the court here is looking at it as a question of scope of the duty. There's then some discussion, particularly at paragraph 36, of Balstead, and then we see the conclusion at paragraph 42, that it follows that even if there was a fiduciary relationship, the scope of the duty is limited where the principal knows that his agent is being remunerated by the opposite party. As Balstead say, etc., etc. Paragraph 43. There was no question, as there was in Balstead, of any extra commission being paid over and above what had been agreed. there's obviously a resonance. Obviously, it's not a direct analogy in our case, but there's a resonance with our case about the point the judge makes, that while they knew that in our case, and one of the reasons I say it's stronger, is that the appellants here knew that the fiduciary was getting 100%. So it's sort of opposite to Medstead, because in our case, the fiduciary gets 100% of the fee and then pays other people out of it. But anyway, the conclusion in at the beginning of paragraph 44 is that there's no duty. And then if we turn to paragraph 46, is the overall holding that on the facts there was no duty to disclose the exact amount of the commission received. So one way of approaching our case might be to say, well, on the facts there is no duty to specify the paragraph 27, the three so-called required disclosures. Or, and this is the important bit, to put the matter another way, to the extent that Medstead was the fiduciary of its clients, it was not a breach of duty for it not to disclose the amounts of commission it was receiving. So, this, in my submission, supports my point that really it's two sides of the same coin, ultimately. Because if you're going to do what my learned friend says and analyse matters in terms of what's the scope of the duty, the answer to that shouldn't be any different from what needs to be disclosed in order to get the informed consent of the principal. And that's really what Lord Justice Longmore is saying here. You can either say there's no duty, or, to put it another way, there's no breach of duty not to disclose this point.
I mean, if you take that too far, you actually get rid of the no conflict principle. Because the duty never comes into existence in the first place.
Exactly. But that's why, and as Lord Justice Saccaroli and Manhattan say in the subsequent case of NG, this is a when they're talking about the scope of duty, it's a conclusion on the facts of the particular case. And that's the important thing, is it all depends on the particular case.
But am I right in thinking that Medstead wasn't referred to in Hopcroft?
I need to check that. I think that's right.
That's right.
And the cases that do address this topic, which are Herstanger and the Anangel, do so by an analysis of what information is or isn't material for the purposes of informed consent, not on a scope of duty basis.
The second point is exactly right, my lord. Yes. And I'm not saying, sorry, my lord, I'm not saying you need to do it as a scope of duty point. My whole point is the judge was right. There's no conflict duty. You then ask if there's informed consent. What I'm doing here is responding to my learned friend's submission that there's a positive duty of disclosure. There's a number of reasons that's wrong. But even if it's right to look at it in that way, then Medstead tells me, or tells us, that it's all a question of fact in the particular circumstances of the case. And in our case, the only conclusion could be that there is no duty. But my lord is quite right. Herstanger, Anangel, Imperial Mercantile, Hopcroft look at it in the same way that the judge did, which is to say there's the no conflict rule, only defence is informed consent. Was there informed consent?
for completeness, one sees from page 1686 that Medstead was cited in argument in Hopcroft, but not cited in the judgment.
But in any case, I'm not making necessarily a technical point here, because even if one were to re-argue and re-decide Medstead in the conventional way that we've seen in Hopcroft, so there's the no conflict rule, the only question is was there informed consent. It's blindingly obvious in my submission that the answer of the Court of Appeal would have been the same. To put the matter another way, as Lord Justice Longmore puts it, there wouldn't be a breach. Why wouldn't there be a breach? Well, because there would be informed consent. So it doesn't matter how you analyse it.
So have I got your argument that the right way to look at it is what you described as the mercantile, Hopcroft, whatever way, that it's all about informed consent. But if there is a separate, if it's an aspect of duty, the extent of the disclosure which is required can only be of such information as would be required for the purposes of informed consent.
Precisely. And as I've said, I really struggle to see how the appellants could succeed in our case in light of Medstead, because the appellants in our case had a greater understanding and knowledge of the commission arrangements than the sophisticated clients in Medstead did. Lords, my lady, unless there are any questions on that, I think we can put Medstead away. That's all I wanted to say, really, by way of general principles. So that's my second heading. My third heading is to address ground 1, which I'll move to now. And I think if we could turn up the appellants skeleton, please. That's core bundle tab 13. Sorry, before I address ground 1, actually, can I just, while we've got the skeleton up, the diagram at the end of the skeleton, page 470, we looked at yesterday. I just want to be sure that you've understood. When you see all those numbers there, those numbers don't have anything to do with the claimants. Those are the totals. Obviously, the bits of those numbers that are attributable to the claimants' investments are a fraction of those numbers.
The proportions would be right, would they? The proportions, if you compare, I don't know what, 24.92 million going to the general partner and 5.14 million.
Yes. I haven't done it for today's purposes, but I did at trial try and show the judge if you were going to attribute those numbers to the claimants' investments, how it would work. But the main point is, obviously, they want to have big numbers to make it look bad, but the numbers that are attributable to the investments are much smaller. But can I look at ground 1, please? And it begins in my only friend skeleton at paragraph 26, page 443. Because it's actually quite difficult to pin down exactly what the appellants are saying. on ground one. And it seems to me, from the skeleton at least, together with what my learned friend said yesterday, that there are 2 limbs to it. So as I understand it, the first is in paragraph 32 of the skeleton. Which I think we then see elaborated in paragraph 48, which is on page 451. The further moulding or narrowing of the duty. So, as I understand it, there's an assertion here that the judge failed to decide what the fiduciary duty was, and that he inappropriately moulded or narrowed the scope of the duty. So that's, as I understand it, the first limb. The second, I think, is really what we see in paragraph 44 of the skeleton, page 450, which is that the so-called required disclosures the judge should have held that they were positive obligations placed on XY as part of its duties of disclosure. And that seems to be elaborated in paragraphs 52 to 54 of the skeleton, which is section C.1.6. The judge wrongly conflated the scope of the duty with the separate informed consent issue. So can I just deal with them in that order?
Just to clarify my own thinking, what I understood to loom large yesterday in relation to ground one was the proposition that there was, so to speak, a freestanding duty to disclose all material facts.
Yes, so the second limb in my...
That's it. So that's your second limb, yes, that's it.
I think that's right. The first limb, I mean, I don't really want to spend any time on the first limb, because the first limb is absurd, and we can see it's absurd from paragraph 48 of the Appellant's skeleton. But the short point is that there is simply no suggestion anywhere in the judgment that the judge was embarking on any sort of narrowing or moulding or curtailing, to use the Appellant's word. And this is what the judge makes this point in, we don't need to turn it up, but in his refusal of permission to appeal at Core Bundle tab 9, page 417, paragraph 2. In the middle of paragraph 48, the appellant say, given the judge's approach to the issue, he made no finding that the duty ought to be curtailed. So far, so good. But had he, as he was required, grappled with that question, he would or should have answered it in the negative. So, it's saying the judge shouldn't have been doing any curtailing. He didn't do any curtailing. And if he'd asked himself whether he should have been curtailing, the answer should have been no. Well, that was the answer that the judge gave. So,
I assume on this thesis, really, the first point feeds into the second point. Since you haven't moulded or curtailed the duty, you are left with the untrammeled third duty to disclose.
In which case, I'll move on to, as it were, the second limb, which is this positive duty to disclose all relevant matters. As I say, we can pick that up at, I think it's paragraph 52 of the appellant skeleton. And the way it's put in paragraph 53 is that the no conflict rule and no profit rule, so the conventional fiduciary duties, are just an ab initio duty. Which you then need to supplement by a plethora of more specific consequential duties. Basically what paragraph 53 is saying. We say that this is all just nonsense and it has no support in the learning. And there are really three main points that I'd make under this limb of ground one. First, even on the appellant's case, this seems to be an entirely semantic point. Because they say that the allegedly non-disclosed matters would have needed to be disclosed in order to get fully informed consent. So,
yeah, but they say they don't need that. As I understand it, they say, ground one, there's a positive obligation to disclose all relevant matters, and if there's a failure to do that, then that can be an independent ground on which they can succeed, irrespective of whether under ground two there was or wasn't disclosure sufficient for informed consent. That's how I understood the point was being put.
In which case, my lord, the answer is no, for the reasons that we have discussed already this morning. Yep. Before I had to have a quick look at the authorities on that, you've also got my point that if you read the judgment as a whole, the things that were allegedly not disclosed were, in my submission, in fact disclosed or sufficiently disclosed. So that if you're going to go down this route of a positive duty, I'm not saying you should, but if you were, you could only conclude that all the things that we did disclose were sufficient, were the things that were required to be disclosed and nothing more.
I mean, where this would bite would be if in one way or another the appellants had given informed consent because they knew things, but those things had not been disclosed by you.
Yes, and so it's in your lordship's example yesterday of the solicitor who tells the client A, B, C, D and E, but not F. Well, the trouble with F in my learned friend's case, before you get to the authorities, is that F is nothing really to do with the conflict. When he makes all his points about, oh, well, Twinkle was unregulated, it had no track record, etc., etc. Well, that's not really about the conflict. So, in my submission, F could only possibly be relevant. See Hopcroft. It's got to be material to the conflict, and it's got to be material to the conflict so far as the particular appellant is concerned.
I mean, I suppose taking it a stage further, just in terms of conflict, as the judge found, you told the appellants that you were behind the fund and that you owned the general partner. And as the judge saw things, the recipients of that information understood from that various other things. So I suppose it could be said, well, you didn't in terms tell them those other things, those were not disclosed.
Yes, on that analysis, but it doesn't matter because, as I hope I demonstrated by reference to Hopcroft, the court doesn't shut its eyes to what the particular claimant knew and how the particular claimant received the information. It'd be an utterly pointless analysis, Malone Friends analysis, that is, because even if you did the analysis, there'd never be any loss recoverable.
I think Mr. Sewell was reserving his position on that yesterday. I mean, on conventional but-for causation approaches, obviously there could be no loss, but I think he was reserving his position.
Anyway, in this regard, NG, in my submission, which we looked at yesterday, is clear authority. That the question of the scope of the duty is the same as the standard that the court applies to informed consent. I won't turn it up, but...
But it was accepted, wasn't it, in that case, that the factors which would have gone to informed consent were the same as those which would have gone to duty. That was accepted.
It might just be worth, before we go to NG, if we could turn up, please, in Authorities Bundle 4, tab 43, Snell.
My recollection is that this bit is written by Professor Conaglan.
It is.
Yep.
Yes, so it's full of prophylactic and proscriptive stuff. On page 1875, at paragraph 7014, the point is made about it all being proscriptive. The point about Snell is that before the judge, we just both relied on Snell. We didn't get into, as it were, the weeds of all of these cases in the way that we're doing now. And then if we turn over, please, to page 1878 at the top. And this is in the section discussing the scope of the duties. If you just read that. So, Snell, I think, read NG in the same way as I do, which is the question of scope is really just the other side of the coin.
Does that mean that footnote 128 takes you to NG?
It does.
It does.
Shall we just turn up NG, my lord? It's at tab 36 of the same bundle. I think we can pick it up at page 1509.
I'm sorry, because I have mine split up. Volume 4.
Tab 36, my lady.
Thank you. Yep.
And we see the issue in paragraph 43. The issue is whether, as the judge found, informed consent narrows the duty, or whether it operates to negatize what would otherwise be a breach of duty. So, in a sense, same question as arises in the present case. As in the present case, the court observes at 44 to 46 that nothing really turns on this, because it's all the same factual material anyway. That's why in paragraph 44 they say that really the battleground is informed consent. The conclusion is at really at 52 to 54. Sorry, I should just say, in 51 you get where the judge was coming from between D and E. The judge based himself on the extent to which Tooling knew or could be expected to find out about the commission.
So they could be expected to have found out and made all this rather more sensitive.
Yes. But for my purposes, I obviously am happy with knew. But then the court go on in 52 to 54. That all of the relevant matters which relate to the sufficiency of disclosure or the adequacy of disclosure are more appropriately regarded as being relevant to the question of informed consent rather than what the duty is in the first place. And then they explain that in 55 to 56. That the question is whether the duty was breached because there was no informed consent. There's no suggestion the scope of the duty is curtailed. But equally, there's no suggestion that the duty is expanded by it either. And logically, I say it's the same. Just while we're in this, informed consent is obviously ground 2, but that's dealt with in it's really 67 following. But the point about NG, to preempt what I'm going to say under ground 2, is 75. The court in NG only interfered with the judge's conclusion of his either conclusion of fact or evaluative decision, whatever you want to call it, on the conventional basis that there was an error of law. That's obviously important when we come to round 2 because, as you know, I say that one of the problems with the Appellants case is that they can't interfere with the judge's decision. We've seen how Hopcroft essentially makes the same point. That really the only question is there the duty, is it breached? Is there informed consent? Whether it's breached and whether there's informed consent are two sides of the same coin. We saw that yesterday in Maguire. And if I could just, we could put away bundle 4 and take up bundle 1, please, and have a look at Maguire, which is in tab 7.
Just give me a moment, Mr. Purdy. I have too many files out. You wanted me to go to?
Tab 7, bundle 1, my lady.
Thank you. I'm sorry, thank you.
So page 147, please. We looked yesterday, I think, at the final paragraph on this page.
I'm so sorry, which page?
147.
Thank you.
What is, thirdly, and then halfway through, what is required is for fully informed consent is a question of fact. There's no precise formula which will determine in all cases if informed consent has been given. And then over the page, passage beginning however at the 3 lines down. It should be noted that contrary to the respondent's suggestion, there was no duty as such to obtain informed consent. Rather, the existence of an informed consent goes to negate what otherwise would be a breach of duty. And that's the right analysis in my respectful submission. Whilst we're in bundle 1, could we please now turn to tab 14, which is the item software case. And I think we can pick it up at page 421. And in paragraph 40, starting at G, five lines down, in addition, it is often said that the fiduciary must disclose a conflict of interest and duty because that is a shorthand way of stating the mechanism by which he can avoid any liability to account for secret profits. So, whatever else Lady Justice Arden is saying in this case, the no conflict rule is just the no conflict rule. It doesn't mean there's a duty to disclose. People just use that shorthand because the mechanism to waive any breach is informed consent. And then over the page, paragraph 41. Her Ladyship says, I don't consider it correct to infer from the cases that a fiduciary owes a separate and independent duty to disclose his own misconduct to his principal, or more generally, information of relevance and concern to it. So to hold would lead to a proliferation of duties and arguments about their breadth. So just pausing there, whatever else Her Ladyship says, I obviously throw that in aid. There is no separate or independent duty to disclose more generally information of relevance and concern to the principal. So my learned friend's way of putting the duty just doesn't work. On the facts of item software, Her Ladyship went on to say that the fundamental duty to which a director is subject did mean that in that particular case the director should have fessed up. But what this case does not support, indeed its authority against, is the notion that there is a separate and independent duty to disclose information of relevance and concern to the principal. And you could see how there would just be an enormous proliferation, because in this case, my learned friend has only come up with 3 particular duties in paragraph 27. But you would end up having, no doubt, if you adopt this novel approach, there'd be no end to the duties debated. And I know my Lord Justice Newey drew attention to the Maru case.
I'm not sure that what I was saying in Maru, I mean, it went further on the particular facts, but I think the underlying idea that it was based on duty to act in good faith is consistent with what you've just said.
Exactly, and that's all I was going to say about it. I don't think Maru goes beyond that.
No.
More generally, I do sound a note of caution about this prescriptive positive duty that my learned friend is gunning for, and his reference to item software and Saxon Woods from the Supreme Court the other day. Those 2 cases are company director cases, and there is no doubt that a company director owes a duty to act in what he considers in good faith to be the best interests of the company. In case this case goes any further, I am not to be taken to accept that principle, which is now enshrined in section 172 of the Companies Act, necessarily applies to all fiduciaries of any kind. Indeed, I'm not aware of it being applied outside the company director's context. And the only other case I can think of where it applies is a case called Shepherd Investments and Walters, which is one of the director's resignation cases where the director cynically resigned in order to steal a corporate opportunity for the company. There's a pretty good discussion of this in Grant and Mumford, if anyone is interested, but they essentially make the point that these are deep and difficult waters. In my submission, we don't, in our case, need to get into them.
You get a linked debate about whether the duty to act in best interest is a fiduciary duty.
Yes. I see the time.
Yes. So how close to the end of round 1 are you?
I'm near the end of round 1, but I think not so near that we should probably break now, my lord, if that suits.
Yeah. Okay. 2 o'clock.
Thank you.
What rise is it?